Ready, start. This appeal under Section 173 of the Motor Vehicles Act 1988 is directed against the judgment and award dated 18 July 2006 of the Motor Accident Claims Tribunal, Vadodara, in MACP number 1470 of 2003, awarding compensation of rupees 3,91,200 under Section 163A of the Act to the widow, a minor son, and the parents of one Yatin Kumar Patel, who died at the age of 26 years in a motor vehicle accident. Para. At about 9 pm on 14/4/2003, when the deceased was driving the motorcycle insured by the appellant insurance company from Dubai to Sadli, suddenly one pig dashed with the motorcycle. The deceased was therefore thrown off the motorcycle and fell on the road, resulting into serious head injuries. The deceased was rushed to the hospital but succumbed to the injuries on 20/4/2004. The parents, widow, and the minor son filed the claim petition under Section 163A of the Act. Para. The insurance company contested the claim petition mainly on the ground that the deceased himself was driving the motorcycle and therefore his heirs cannot claim compensation under Section 163A of the Act. Relying on the decision of this court in New India Insurance Cooperative Limited versus Muna May Basant, the tribunal negatived that contention and passed the award in favor of the claimants for compensation of rupees 3,91,200 after considering the income of deceased from agricultural lands and after considering the age of the deceased. Para. The only contention raised in the appeal is that since the deceased himself was driving the vehicle in bracket two-wheeler scooter, the insurance company is not liable to pay compensation. It is vehemently submitted that the insurance company's liability to indemnify the insured can arise only when the owner is vicariously liable for the negligence of the driver, and therefore the driver himself or his heirs can never claim compensation even in a petition under Section 163A of the Act. It is also contended that in Section 163A, absence of provision similar to subsection 4 of the Section 140 and use of the word victim in subsection 1 of the Section 163A support the insurance company's case. Para. In the first place, the liability of the insurer under Section 140 and the 163A of the Act is an independent statutory liability and not a common law tort liability. Liability of the owner oblique insurer to pay compensation under Section 163A arises as soon as it is shown that death injury resulted from an accident arising from the use of a motor vehicle. If the insurance company is permitted to disown its liability on the ground that the driver of the sole vehicle involved in the accident was at fault, that would run counter to the clear provisions of the Section 163A and the legislative scheme in introducing Section 163A will be frustrated. The legislature, having specifically made the question of negligence irrelevant in a petition claiming compensation under Section 163A of the Act, it is not open to the owner oblique insurance company to dispute the liability to pay compensation by raising the plea about negligence of the driver of the vehicle. Para. The liability to pay compensation under Section 163A is on the principle of no fault, and therefore the question as to who is at fault is immaterial and foreign to an inquiry under Section 163A. Section 163A does not make any provision for apportionment of the liability. If the owner of the vehicle or the insurance company is permitted to prove contributory negligence or default or wrongful act on the part of the victim or claimants, naturally the claimants will have to lead evidence which would defeat the object and the purpose of section 163A. Legislature never wanted the claimant to plead or establish negligence on the part of the owner or the driver. Once it is established that death or disablement occurred during the course of the user of the vehicle and the vehicle is insured, the insurance company or the owner, as the case may be, shall be liable to pay the compensation. This is a statutory obligation. Claimant is therefore entitled to get legitimate amount on the basis of the structured formula based on the no fault theory from the insurance company or the owner or owners of the vehicle on the plea that the liability is joint and several. Para. Counsel for the insurance company also raised the contention that since section 163A is incorporated in chapter 10 with the heading Insurance of Motor Vehicles Against Third Party Risks and driver cum owner is not a third party, and hence if the death or permanent disablement has resulted due to his or her wrongful act or neglect or default, claim is not maintainable. We find it difficult to accept this contention. The head of the chapter was there even before the introduction of section 163A. The word third party has been defined as an inclusive definition under clause G of the section 145. An inquiry as to whether tortfeasor is a third party, owner, or driver does not arise when a claim is considered under section 163A. No fault liability under section 163A is one created by the statute falls outside the purview of tort, there be there being no necessity to enter into an inquiry as to who was the wrongdoer.